Today's session, MCLE, is Defending Positive Toxicology Petitions and Other Substance Abuse Cases by Emily Berger. I'm sure she needs no introduction, but I'm going to introduce her anyway. Hopefully this works.
Yeah, let's turn this one on. Hold on. Hello.
Hello. Okay. So Emily Berger is a supervising attorney at Ladle 2. You will see her name, or should see her name on several appellate decisions that were in her favor. One of which is Rebecca C., which you will see in the materials. And as Marlene Firth told me, is alive and well and should be cited and used appropriately. And with that, Emily Berger.
Thank you for being here and thanks for tuning in. This is going to be, some of this will be reminiscent for those of you who have been to my happy hour series, but hopefully there's enough new information to also keep you interested. So I wanted to start with our positive toxicology cases where a child is born exposed. So I will start this by saying, and Marlene will back me up, that I really is a huge problem for me when I hear the term drug baby. I think that we end up giving the department exactly what they want, which is stigmatizing our clients and stigmatizing their children. There's no such thing as drug babies. There are babies that have been born exposed to certain substances. I am waiting for the time when California, and I think it's going to come out of Ladle, for us to have a published decision that is going to stand for the premise that not all children born exposed to substances are automatically coming within the jurisdiction of this court. Now, the case that right now we need to be able to distinguish is In re Troy D., which is from 1989. It was a terrible case, and it's what the department is always going to be citing to. I think what the appellate attorney was trying to say was, when Troy D. was exposed to drugs, he wasn't a child. It was sort of this concept of, we're not going to give rights to a fetus. He was exposed when he was a fetus, and therefore this should not have been jurisdictional. And the court said no, because he suffered the harm after he was born. The quote is that he is not a fetus, but a living child born with dangerous drugs. His mother used drugs while pregnant with him. So the child, tested positive for amphetamines and opiates in his urine, and there was a doctor that testified at that trial. Dr. Suzanne Dixon testified about the harmful effects and potential long-term consequences of prenatal exposure to dangerous drugs. And really, the reason why this case never should have been, frankly, even argued, but of course, maybe the mother was just adamant, she wanted to go to trial, and it certainly should not have been taken up on appeal, because this was a child who was born premature, low birth weight, had withdrawal symptoms, had a longer than normal hospital stay, poor feeding, lethargy, and weight loss. So this was not the child that we could point to and say, what are you talking about? This is a healthy child. This child has not been harmed by any behavior of the mother. But New Jersey, it turns out, in 2013, had the case that I'm waiting for one of you guys to make for California. So the mother tested positive for cocaine, the baby tested negative, meconium tested positive for cocaine, and there was a confirmed positive test of cocaine. And that's important because we're going to talk a little bit more about the drug tests that we get attached to our reports or that we have in the hospital records. Here there was a confirmed test of cocaine for the baby's stool. So this wasn't a situation where the attorney was going to say, this never happened, the baby didn't actually, this wasn't a good test. I always put this in when I talk about this case because our courts get very upset when parents aren't forthcoming and they don't tell the real story. They make up some crazy story about why they tested positive or why the drugs were found in their purse and it wasn't their purse, it was their friend's. So the mother denied using drugs. She said that she and the father picked up an intoxicated friend from a bar, The friend sat in the back seat of the car. When mother saw the friend pull out a plastic bag that appeared to contain cocaine and start to use it, she grabbed the bag to get rid of it. The bag exploded and the cocaine spilled all over her in the car. So obviously that is how she tested positive. So I love this story. Of course, when I told this story to Dennis Smeal, he was like, that sounds like a really plausible explanation. The APGAR score, which, does anyone know, or can someone tell me what the APGAR score stands for? So the APGAR score stands for appearance, pulse, grimace, activity, and respiration. And that's the metric that's used to determine how healthy a baby is at birth. It's measured at the 1 minute and the 5 minute mark. We're usually looking for scores 8 to 10 is what you really want. 7 is still pretty good, and then anything below that, you're going to have a problem. So this baby was born with a really high APGAR score of 8 and 9. He was discharged 2 days after birth. The appearance was normal, and the discharge after birth is really important because what does that mean? It means he wasn't having respiratory problems, he wasn't premature, he wasn't in the NICU. This was a totally healthy baby. Now, in this case, there were no witnesses testified regarding any scientific evidence, and the court noted that impairment to a newborn can be shown by the following: withdrawal symptoms, respiratory distress, cardiovascular or central nervous system complications, a low gestational age at birth, low birth weight, poor feeding patterns, weight loss through extended hospital stay, lethargy, convulsions, tremors. So while you can't use this case for citation, obviously, you can pretty much pull out all of this language because that's exactly the language that's going to differentiate your case with the appropriate healthy baby from Troy D. And I just love that it states that not every instance of drug use by a parent during pregnancy, standing alone, will substantiate a finding of abuse and neglect. So it has to be the right case. You have to have a healthy, full-term baby. But I really feel this is the next frontier in juvenile dependency law, and I am just really excited to see it happen, and I think that it's going to be one of our cases. So there are two situations that we often see. The first is the mother states she never used drugs. The only test we have is non-confirmed. It says on the test this is a non-confirmed test. It should not be used for legal purposes. This is only to be used for medical purposes, and the child is born healthy. So in that case, you want to attack the test. I have spoken to toxicologists who've indicated that if a mother takes NyQuil right before giving birth, a non-confirmed test can come back positive for amphetamines. Then when it goes back for a confirmed test, or if the mom then goes in for a Pacific Toxicology GCMS confirmed test and it comes back negative, then you know, okay, that wasn't actually any sort of methamphetamine use. The other situation is that the mother states she used during pregnancy, or there is a confirmed positive drug test. And there are two situations under that. Now, if the child is born with the symptoms that we saw in Troy D, settle the case and move on. If your client insists on going to trial, you'll make your record just like we do for any client who wants to go to trial, but you're going to understand this is not a case for appeal. This is not a case to go hard on, to put on tons of witnesses or have testimony. This is a case that is jurisdictional. Now, of course, there's going to be those situations where perhaps the baby was born with some genetic anomaly, or there are children in the NICU whose parents didn't use. The problem is that if you also have a positive drug test, this isn't going to be the test case that's going to win it for us. And then finally, if the child is born healthy, just like we saw in the New Jersey case, I urge you not to settle that case. I think that there really is a culture in the courthouse of people saying, well, how are you going to argue this case? The baby was born positive. The baby tested positive for meth. And we need to be looking at all of the facts because, like we have seen, if we have a healthy baby, I truly think we can get a case like the New Jersey case. I also think it's going to require not only a very healthy baby, it's going to require a cooperative parent, someone who has either said, yes, I used and I've stopped and I'm testing negative, or if they're not acknowledging use, as long as they're testing negative and complying. We're going to look, that sort of goes into the nexus argument, which I'm going to get to. But it does have to be very specific. It has to be very specific facts. And I don't want our possibility of success to get watered down by arguing every case. You need to look at the case as a whole, obviously. And I think with our right fact pattern, we can absolutely get there. So then we've got substance use versus abuse, our fabulous Drake M case, which was from 2012. And that talks about the fact that we're talking about the tender years presumption. So we see it in almost every petition. I've seen it with kids, in fact, older than 10, that they say that, you know, this is a child of tender years. The case law seems to suggest that 6 and under is really what they are thinking about when they're talking about tender years, and it's a rebuttable presumption. So I'm sure everyone's familiar, but I'll just run through really quickly, which is that the department wanted to say because the father was using marijuana and Drake was 14 months old, he was a child of tender years, father's a substance abuser, jurisdiction, that's it. And because it's a rebuttable presumption, the court found that DSM factors of abuse did not apply. The father had no failure to fulfill major role obligations at work. He did not have recurrent substance-related legal problems. He had not been under the influence when driving or caring for the child. He did not continue to use substance in the face of having persistent social interpersonal problems caused by substance. Now that last piece is going to be really important when we talk about In re Alexander C, which is coming up. So the court also noted that no expert testimony or police reports had been presented documenting that the father was under the influence while caring for the child, so therefore that presumption was rebutted. The father was found to not be an abuser, he was merely a user. It did not place the child at risk of harm. And then we've got Rebecca C, which does keep popping up. And there were two arguments here. On appeal, and I argued at the trial level, I first tried to argue that mother was not an abuser, she was just a user of substances, and the court did not agree. The court very clearly states in re Rebecca C, no, this mom is a substance abuser. She had a criminal history, she had no employment history, she did have persistent legal problems, she had a history of relapse, she had a history of lying about drug use, and she had a rationalization for her use of drugs. So the court said, yeah, her drug use is a problem, but because this child was not of tender years, Rebecca C was 12 or 13, then we get to the nexus question. So, all right, she is a substance abuser, but the department still has to show there's a nexus between the substance abuse and harm to the child. And they said, she's 13, this kid, there's no physical abuse, she's up to date on her dental and medical, the home was clean, it was well stocked with food, mother attended IEP meetings, mother enrolled in programs ASAP, so we still need that causation and harm, and the court stated if DCFS's position were accepted, it would essentially mean that physical harm to a child is presumed from a parent's substance abuse under the dependency statutes, and that it is a parent's burden to prove a negative, i.e. the absence of harm, and that is not what the dependency law provides. So that's, I do think it's interesting that, I mean, it's great for when you have kids that are a little bit older, obviously. I think for, 9, 10-year-olds, you're still going to try to be arguing Rebecca C, and the department's going to be saying, no, leave this kid's younger, and it's just going to be how you can craft your argument. One thing that I thought was interesting about Rebecca C, and I used it in my argument at the trial level, I always like to see how the case originally comes in. So this case did not come in because mom was driving under the influence or someone found drugs in the home. It came in because a neighbor was mad at her, and they called in saying that there was no food in the home and the kid was being starved. So the department came in, investigated. They said, no, this is fine. It's a well-stocked kitchen, all this stuff. oh, and by the way, will you drug test? So, and then she had just come back from Las Vegas, had left her daughter in the care of her adult child, and tested positive for meth. So had she said, you know what, it's not a good day, I have a job interview, and had managed to wait a couple days and gone to GNC, cleared out her system, you know, they would have closed out the referral. And it was, you know, for me, I was trying to tell the story of this family, which is that nobody had concerns for this child having not having her needs met because of drug use by the mom. This was a nefarious neighbor who was calling in a bogus referral, and that was all in the report. So we have these recent cases that we need to distinguish. In Ray Alexander C. affirmed Trong. So father used meth continuously for 25 years. And this is where I got a little freaked out when I read In Ray Alexander C. And I felt like, oh my gosh, is Rebecca C. dying? You know, all of these things. But when you really come down to it and you look at the statements from the father, so much of what I think made this case different was the father's own statements. So he said he needed it daily, and the amount of time he used had increased dramatically over time. He did have the recurrent legal problems with current prior dependency matters. Now, if you think about Rebecca C. and you think about this nexus, I totally understand how the trial counsel were saying, look, these kids were teenagers, they're doing well in school, we've got an adult sibling who comes over and cares for the kids daily. But then that ended up being a double-edged sword, because where I think trial counsel and appellate counsel were trying to say they've created this safety plan, they've created their own safety plan for the adult sibling to come in and help, the appellate court said, well, they passed it off, they delegated their parenting duties. And in fact, the adult sibling was responsible for the kids thriving, and the parents were actually doing nothing. So the court found that father normalized drug use and provided opportunity and access to the drug. The second case that we want to distinguish was a case that was upholding birdsong, In Re LW. So here's the good part about LW, right? I'm reading it and I'm like, okay, like this is looking good. We've got a 13-year-old, she feels safe with the mother, there's extended family support. Everyone was shocked to learn of the mother's drug use. There were adult siblings, they had no concerns regarding the mother's parenting. And then similar to Alexander C., adult siblings had helped mother in caring for the child. The child never saw the mother use drugs. The child was well fed, well groomed, and attended school. So you're looking at this and you're thinking, okay, Rebecca C., where's the nexus? This kid is doing great. But then you're looking at the whole story. So the referral was received March 16th. Then a month later, mom was still not in a program as she had agreed to. She had an extensive criminal history spanning from 1993 to 2017, including a DUI 6 months before the referral. And then in April, so a month later, there's the detention hearing. By May 31st, mother's still not in a program. She self-reported daily cocaine use. She continued to test positive even after DCFS involvement. And then she stated she took shots of vodka along with cocaine to help her prescribed medication work. It's like an activator. So, on the one hand, you've got this kid who's doing great. On the other hand, you've got this mom who's ruined the case for you, right? And you're just like, if only, you know, this would have been a great case to get birdsong reversed if only you had a better client. So when I'm looking at In Re LW and Alexander C., what they're talking about is we need to see the more. What's the more? Because substance abuse without more will not lead to dependency jurisdiction. So, in Re LW, in the year before DCFS got involved, mom was arrested twice for DUIs, and what the court said was the effect of her substance abuse is not now confined to her private moments alone. There were 2 arrests and at least 1 conviction within a year of the referral that shows mother's substance abuse is spilling over into areas that will pose a substantial risk of physical harm to LW. I actually think that's quite eloquent, and I think it's a nice way to think about these cases. Is this just a mom going to Las Vegas in her private moment alone, having some fun, having made an appropriate, limited plan for her child, or is this now really causing a problem for this person's life? The mother had the opportunity to resolve the problem by enrolling in a program, but she couldn't or wouldn't. And she gave conflicting stories about the length extent of her abuse. She hid her abuse from the family, which again sort of cuts both ways because the family was also supporting that she was a great mother. And then she continued to test positive. So this is the thing. Before In re Alexander C. and LW, I used to tell my clients that I would object to drug testing at the detention, and my thinking about this is that a drug test is not going to tell you if someone's a good parent. It's only going to tell you whether they're using substances, but it doesn't matter if they're using substances because that's not what the nexus is. That's not the evidence. Unfortunately, now with this current legal landscape, I do now tell my clients, you've got to agree to drug test and you have to stop using it because that's going to be our way to differentiate these terrible cases, Alexander C. LW. So yes, the parent was using prior to DCFS intervention, but as soon as they got that knock on the door from the social worker, they got into the program and they stopped using and they were agreeing to drug tests and their levels were going down or they've been testing negative altogether. So that's going to be our way to show this is a person who has control, because that's the other situation we've got with Alexander C. talking about cravings and urgings. Well, obviously if someone's able to just stop and comply with drug testing, they either don't have the cravings and urgings or they're at least able to have control over them and not use. So that's the way to combat it. If your client says things like, I'm addicted and I need help, that's going to be a red flag that this is not a case that we can win. You want to look at how continuous the use has been. So 25 years of using is very different than a 22-year-old who started using meth 6 months ago. You want to look to see if the use has increased dramatically. You want to look to see about their recurrent legal problems. Is this the client's first rodeo? I had a case today where we picked up a former client, and this was the letter G. The baby was born positive, and as soon as you see that letter G, you know this is not going to be one to argue. She's had recurrent legal problems. And you can't really, if someone has lost other children, you can't really argue that their drug use hasn't caused a problem. And that is true even if they lost kids a couple years ago, if they essentially got TPR'd on just marijuana cases. When the court was treating marijuana very differently, and now they have a new child, they're still using marijuana, you want to be arguing Drake M and about all of the new things we have to argue, but they're using marijuana after their parental rights were terminated. That's going to be an issue that you're going to need to deal with and probably not be successful. Oh, and you're also going to want to look about where the drugs were stored. So anytime the drugs are in the home, that's going to potentially be an issue. It depends. Sometimes you can use the tender years to your advantage, which I did in the case In re DS. It's an unpublished case. It was in 2015. I got Soto reversed. The fact pattern was that there were 2 8-month-old twins. The parents heavily used marijuana and had a mental health diagnoses, and the apartment smelled very heavily of marijuana. So the marijuana was kept in a bathroom drawer, though the social worker said she saw a pipe on the countertop, and then the parents said that they would take turns smoking. There was a well-stocked kitchen, the twins were clean, they were up to date on their vaccinations, they were both a healthy weight, and there were no marks or bruises. So what the court found there was that the court reiterated that neither mental illness nor substance abuse is enough alone for jurisdiction. The court found that the department's reliance on second-hand marijuana smoke and untidiness was not the more required. The court found the tender years presumption was rebutted and the case was dismissed. And part of the reasoning as well was that while there was marijuana stored in the home, a 10-month-old or 8-month-old twins were not going to be able to go into the bathroom drawer to get it. So in some ways, these 8-month-olds were actually at less risk than a child that, say, 10, who would be going through the bathroom doors. But then the case came back. And this time, they had the more. So 3 years later, the department detained again. The court found the department had met its burden and showed that there was now the required more. It was really sad. It was really sad. And I felt like the parents had sort of been emboldened by their original win. And were maybe, when the social workers came knocking that second time, they were like, well, we already won once. So this time, there were psychologists that evaluated the kids, and they were both lagging behind developmentally. One of the twins had a severe speech problem and had severe temper tantrums. This time, the twins were not really well taken care of. They reeked of urine, the bed smelled of urine and feces. The mother and father not only didn't address developmental hygienic issues, but they denied that they existed at all. They insisted neither kid had a speech problem, and the sanitation issues were only due to sewage problems and potty training. So the court said things have changed. Now there's evidence that the parents used meth as well. So there was also a drug test for meth, which before they were only testing for marijuana. I don't think that's the biggest, I don't think that's the real issue. I mean, the real issue here was the fact that these children were not having their medical and health needs met. The court said, more to the point, now there's evidence of tangible harm to the children as a result of parents' drug use and mental illness, namely the children's developmental delays and unsanitary hygiene, and the evidentiary void has been filled. So it's a sad story, but I do think it's really useful as an educational tool, right? Because you can see how this family changed in 3 years, and how first their marijuana use was really not jurisdictional. And then, unfortunately, as the children's needs changed, it became jurisdictional. And so that's another, it's also interesting to me how in this case, and in many cases, it's a younger child who's actually at less risk of harm. Because now also these are older, mobile children who could have access to the marijuana in the home. And then Whittaker, my favorite guy, I'll tell you the story, dismisses one of the few jurisdictional pot cases I've ever seen. So this is crazy. When I read this, everyone was like, oh gosh, like he just got reversed and now he's never going to dismiss another pot case. And I read the case, and I would have sustained this case. It was insane. So the baby was born substance-free, but was premature. The baby was in neonatal intensive care. The mother smelled of marijuana and cigarettes in the NICU. The child had not received all her immunizations because she hadn't gained enough weight and she needed specialized formula. The mother had been TPR'd on 2 previous children due to the previous marijuana case. The social worker visited mother's motel room and found it difficult to breathe due to the smell of marijuana and smoke. Father stated he and mother smoked 5 to 8 blunts every day. And I was not present during this trial, but I did hear that Whittaker was very confused about what a blunt was. So all of their tests were no-shows, they never tested, and they both had lengthy criminal histories. By the adjudication disposition, which PS was 6 months after the detention, there was still no proof of services for either mother or father. So mother testified. And she testified that she uses her marijuana daily. She spends $25 daily on this, and testified that she could stop. She hadn't stopped after she'd been TPR'd, or after her child was in the NICU, or after 6 months of the case. She also testified that she had an 8 to 9 year history, and she'd only visited the child 3 times in 7 months. So the weirdest part was that the court sustained as a J, the appellate court sustained as a J. I would have sustained as a B. I don't know. I might be getting more conservative in my old age. So it's an interesting case to read if you want to just think about, if you want to read a case about when marijuana use truly is jurisdictional. And then it leads to the question of, what do we do with marijuana smoke? What do we do with marijuana smell? Sometimes it's a problem, sometimes it isn't. So In re Alexis E., which is a 2009 case, found that it was a problem. And what the quote says is that children say they smell it. One of the children said, "It looks like Daddy's going to set a fire on the house and it stinks." And the trial court could reasonably find that father's use of marijuana constituted a risk of harm to the minors because of his failure to protect from the smoke. So while it's true that the mere use of marijuana by a parent will not support a finding of risk to minors, the risk to the minors here is not speculative. There's a risk to the children of the negative effects of secondhand marijuana smoke. Now, the court continues, they cite to the Health and Safety Code section, and they indicate that the record shows that the manner in which he's been using it represents a threat to the physical and emotional health and safety of the minors. So, particularly in a case like in Whittaker's case, where you have a child with respiratory problems, marijuana smoke's going to be a problem. And presumably, if someone was a very heavy cigarette smoker with a child with very severe respiratory illness, that could be jurisdictional as well. Now, in an unpublished case out of Division 8, the court found, so a 342 petition had been sustained alleging jurisdiction based on a dirty home. The court sustained the petition but reversed the removal. DCFS was concerned about mother's Facebook page, which leads me to my other favorite thing, which is that every single person at Ladle should be telling their clients to terminate all social media accounts. I write it on every single NCR form, so I have a record of the fact that I've advised our clients of this. It's always a problem. You never get good information from a Facebook page. So she suggested on her Facebook page she could be using marijuana. DCFS reported that the home reeked of marijuana and bleach, and they deduced that mother was using the bleach to dilute the marijuana odor. They also reported her eyes looked glossy. She said she didn't smoke in the children's presence, but the neighbor smoked and the odor came in through the windows. So the court noted this was a 342, and while dependency proceedings are ongoing, if DCFS discovers new facts or circumstances other than those under which the original petition was sustained, sufficient to state that the minor is a person described in 300, it shall file a subsequent petition. The sustained allegation was a dirty home, but Division 8 said the marijuana smell supports dependency because it can be reasonably inferred from this evidence the mother was not protecting the children from exposure to secondhand marijuana smoke, and they cite Alexis E. But then, Division 2, hold on, did I skip one? Okay, so that was Division 8. So then Division 2 stated that in a separate unpublished case, and this was out of In re DS, the first marijuana case that I got Soto reversed on, Division 2 said, although exposure to secondhand marijuana smoke can be considered in conjunction with other risks, Alexis E., it's not enough by itself, and they cite Destiny S. So the divisions are handling things a little bit differently. Now, Alexis E. had noted that father's marijuana use had a negative effect on his demeanor towards the children and others. Father was irritable after using marijuana. His psychiatrist told social worker that father suffers from concurrent severe panic disorder, and the literature on the use of marijuana states one of the effects of marijuana is intense anxiety or panic attacks. So if you have a case where all they really have is the smoke versus the smell, I would definitely take a look at some of these cases with the unpublished cases. You can be looking at the reasoning behind it, and then of course you can cite to the cases that they mention. And then Destiny S has language too. The DCFS worker quoted minor as stating that although she's never seen the other thing mother smokes, sometimes she can smell it, but not very much. So based on this ambiguous statement, DCFS proclaims it has produced direct evidence that mother failed to protect Destiny from the negative effects of secondhand smoke. The court disagreed. They found no evidence suggested that Destiny was at risk of imminent physical harm caused by the secondhand smoke from mother's use of marijuana. In any event, the logical consequence of the department's argument would be to remove minor children from homes of all smokers in Los Angeles County, regardless of what they smoke. We know of no legal support for this proposition. So you're going to want to be looking at Destiny S and then differentiating Alexis E when you have cases where they talk about the marijuana smoke. And then in talking about substance abuse and petitions, I just noted don't forget about JN. Now, I think JN is a little overused, and I've been guilty of it myself, for sure. Where you want to say, look, it was just a one-time incident, it's such a great case for parents, but you do need to be very, very careful and make sure that it truly is a one-time incident, and more importantly, you have to have a client who's acknowledging that this happened, acknowledge that it was a problem, and is able to testify about all of the things they're doing to make sure that this stays a one-time incident. So, I'm not going to read the whole quote, but basically, you just need to make sure that there's absolute acknowledgement of the problematic incident. There can be no denial. If you're going to successfully use JN, there has to be remorse, testimony, what parent learned, how it will never repeat itself, enrollment in appropriate programs, and again, a true one-time incident. So if this is a situation where the parent had a DUI 10 years ago and then had a DUI 6 months ago, I wouldn't use JN. It's not a one-time incident. It's a powerful case and one that shouldn't be diluted by being used in inappropriate circumstances. I just don't want it to lose its power. So now, what about the pesky fathers who failed to protect from prenatal drug use? So now we're going back, talking about mothers who've used during pregnancy, and they throw in the dad, and they say, well, he failed to protect. So those are really frustrating to defend, because the fathers cannot tie the mom up, force her to go into rehab, and the department will often cite In Re JC, which is a 2014 case where they upheld the finding that father did fail to protect. Here's what you need to know to distinguish, and of course you should read the entire case, but father had stated, last I knew she was using was the last time I used. DCFS contends, and we agree, that this statement gives rise to an inference. Father was still doing drugs with the mother. So she was more than 5 months pregnant with JS, a child he believed was his own, which gives rise to another inference that instead of taking steps to stop mother's drug use during the first 5 months of her pregnancy, he instead abetted and encouraged it. So that's what you need to know to distinguish. Do you have a dad who wasn't even living with the mom, didn't have any knowledge of her drug use, he's been testing negative, he absolutely should not be listed as failing to protect. If you have the father who's living with the mom and the two of them are using every day together, it is going to be a problem. Oh, so I think, was that it?
Yeah.
That was it! So, I knew time wasn't going to be a problem. So, does anyone have any questions or war stories that they want to share? Yes.
I know that for inmates, when it lists the DSM-4 as, the factors to
Yes.
consider. I know that I think the DSM-5 is out now. So should we be trying to use the DSM-5 now?
I do not have any knowledge that the DSM-5 factors have changed at all. The DSM-4 factors are pretty clear, and I also like being able to cite to a published case in the argument. So I'm continuing to use the factors that are laid out in JCAM. Yes.
We've recently been using Dr. Petrushka. We've recently been using Dr. Petrushka, who normally is our pathologist on the F cases, but he's also a toxicologist. So again, remember, you have to be able to also understand when the baby is tested in the hospital, whether that's a preliminary test or a confirmed test, whether it's a test being done by gas chromatography or just the subjective test that they do in the hospital. You're going to get lots and lots of false positives if there's not a confirmed test. You really need to make sure somewhere along the line that either you have access to the actual test, or certainly by the time you get to trial, if the department hasn't provided, if they're trying to get a preliminary test into evidence, you need to, the instant county council tries to put anything into evidence, do an oral motion in limine because it does not meet Kelly-Frye. So there's many ways that you can also attack the actual test. If you have a situation where you have a non-confirmed test and it's not gas chromatography, we've had Dr. Petrushka available for testimony, and he can just lay it out to the judge as to why the judge cannot rely on those tests. So even when you have that positive test on the baby, you really have to look at the test itself to see if it's a valid test.
And along the lines of the test, just really fast, we did provide the case In Re LC, which just came out of Lancaster and is reversing Ibsen. It's an amazing case. And one of the things they did was a toxicologist did testify in this case. And according to the toxicologist, the drug test did not show whether the guardian was impaired as a result of his methamphetamine use, which is another interesting way to use witnesses. I would also note that what makes this case so great in terms of reading it and understanding how you can differentiate Alexander C. is because the guardian tested negative. He was able to show, look, I'm able to stop. I'm just a recreational user. I don't have cravings and urgings. The social worker, there was another witness who testified that she had never observed the guardian in a state where he couldn't properly care for the child. Pedro, the guardian, testified he was responsible for the child and ensured all of her doctor's appointments, went through all the things that he did. And again, he testified that he took methamphetamine when he was at a party at a hotel. So it's a similar kind of fact pattern to Rebecca C., including the older child. And he was able to show that he did not crave methamphetamine. He never purchased methamphetamine. And then prior to the jurisdictional hearing, he enrolled in a drug awareness class. So this pretty much lays out exactly how to differentiate Alexander C. and also exactly how to advise your clients. Amy?
So I just wanted to alert everybody, oftentimes our clients will ask us if they can just test at their program. And usually that seems like a great idea because then they don't have to go running all over town. Be mindful that some of the programs only use the dip test, which can oftentimes give you a false positive. We have gotten into some hot water on a couple of cases that way. And if they're not also testing for the department, or frankly, only testing for the department, the case that we had, the mother did do a subsequent test for the department, but it was several days later. So we had to deal with evidentiary issues regarding those dip tests. So just be mindful of that, and I would never recommend to a client to only test in the program if the only kind of testing they do is that dip test.
Yes, absolutely. So we also provided a flow chart to everyone. It sort of just takes you through the steps that we already went over it in the PowerPoint, but it just sort of gives you a fun little choose your own adventure with regard to babies that test positive. And then you've got our cheat sheet. So I think you guys it's at least a good starting point in terms of filling up your toolkits and just thinking about stuff.
So just a question to follow up with what Marlene was talking about. So she was saying that we got to challenge the tests if we don't have the confirmatory tests. Now, if you can speak a little bit how our calculus may change if there are admissions of the parent.
Sure.
And how the admissions may or may not harm the parent if the child is not having any of the withdrawals or the APGAR scores are high.
Exactly.
Really good question, Jabari.
So that is addressed in the flow chart, you will see. So we don't need to worry about the test. If the client is making the admission saying, yes, I used, do I like it when those tests come in? When they specifically say not to be used for legal purposes? No. But do you also want to pick and choose your battles and not waste judicial time? Yes. So I wouldn't object to the tests coming in. What it's going towards is your client being honest and forthcoming, and then addressing it and attacking it by distinguishing Troy D. And showing that this was a child born full term. It's really important to look at when the child's released. If the child's not being released from the hospital because of health concerns, that is going to be a red flag. You want to make sure that there were no stays in the NICU. You're looking at respiratory problems. and the healthy weight, the high APGAR score, full term. And again, it's really important that these particular clients not have DCFS history, because the idea really is that once DCFS is in your life, you need to make sure that they never come back in. So if you're making the choice to use anything that's going to come out in a hospital test after you've had the experience of having a DCFS case, it is such poor judgment. And it's going to be considered recurrent legal problems. So that's something you really are going to want to look for. And then, of course, look for the safety plan. And then that's why we say, so even if the client admits to the use or there's a confirmed positive test, you're not dead in the water as long as the baby is doing really well. So think about having the pediatrician or the doctor testify about the baby's health. You can talk through the language of the New Jersey case, obviously not citing it. And then you look at Troy D and explain all the ways in which this case is not like Troy D. And you've advised your client to enter into some sort of drug, some substance abuse classes. They are complying with testing. They're showing, look, I've stopped. They're not having those cravings and urging. So I think it can absolutely still happen. That's what happened in the New Jersey case. The mother made up this crazy story, but in the end, the court said this was a healthy child. And Jabron and I had also talked recently about what to do if you've got a 12-year-old and a 10-year-old and then this new baby that tests positive. So, a couple of different things you can think about. You can use the 12-year-old and the 10-year-old to show, look, this is a parent who's appropriately parenting. Show all the different factors that they want to see. They're going to school, they're excelling in school, they don't have any criminal problems. This is a family that doesn't have DCFS history. The children had no idea that the mother was using. And you can at least argue to get those older children back in the home or dismissed from the petition. And you can also try to anchor it as long as that baby that's born has not had health problems. Go ahead and argue Troy D and try and get the entire petition dismissed. But I'll never forget that when I first started, I had a case in 414, and there was this baby born positive for opiates with withdrawal symptoms. The baby was not doing well, but there were these two older kids who were extraordinarily bonded to their mother. They had no relationship with their father. The department had pulled those kids, placed them with the dad. The kids were so upset. They were not doing well with the father. And because I had this baby that tested positive and had withdrawals, I just settled the whole case. And I regret doing it, and I wish that I had differentiated the two older children and argued that they shouldn't have been part of the petition at all because those children were not at risk.
And just another question, you had talked about positive amphetamine tests potentially being NyQuil. Have you had any experience with other tests coming back positive? A client saying up and down, adamantly saying, I did not use, it must be the flax seeds or the poppy seeds on the bagel.
I think Stephen O'Reilly, did you have a case with a false positive?
We did.
Do you know what it was that created the false positive?
No, we don't know yet.
Okay.
I know that a mother was ridiculed in court when she said that it could have been from unprotected sex or saliva.
Well,
You don't know if that really happened or not. He does it so seriously all the time. I'm like,
But we did get the gas chromatography test after and got the child released.
yay.
So it was negative on the gas chromatography?
Yes.
Right. So I've typically seen Sudafed and NyQuil will come back with unconfirmed amphetamine tests. I know Adderall obviously can come back positive.
Vicks and Phelan.
Yes, Vicks.
But if you test for the isotopes, I had somebody say it was Vicks. I looked at the isotopes and it really was not.
And
You have to check, yeah.
that's something important to point out. They used to not test for the isotopes, but now if you look at your positive test, they almost always have the isotope breakdown in DS for drugs, and it's almost always. So we used to be able to make that argument more successfully.
I had a false positive for PCP just
Oh.
through ibuprofen, which is probably one of the most commonly used medications in the world.
Oh, wow.
I gave it to Ed, I don't even remember the case, I'm sure he has it, but expert testified that ibuprofen, which is Advil, can cause a false positive for PCP.
Wow.
We don't see a lot of PCP, but if you see it, just ask your client if she's taking Advil. Granted, mine, they took a lot of Advil.
And that was an unconfirmed test or confirmed?
Confirmed.
Oh, wow. Yeah, I had no idea.
When you're interviewing your clients and the client is adamant that, you know, they weren't using anything, and there either is a positive test for them or a positive test for them and the baby, ask your client at the time, around the time of birth, were they taking any medication? Okay, that's a really important question to ask her in the interview. We had a client who had lupus and was taking her lupus medication throughout her pregnancy up until the time of birth. And we didn't know, so that was the case that we had got a hold of Dr. Petrushka, and he was able to explain what the compound is in the lupus medication. Was it your case,
Yeah,
Jody? Yeah, so we got that one dismissed, yes?
yes.
So we got it dismissed because our toxicologist was able to explain that it was the lupus medication that was triggering it. And, you know, it goes to our client's credibility that she wasn't using, but she was just taking her medication. So it's an important question to ask when you have these cases. Are you on any medication? What is the medication? And then you can just start Googling it or get the toxicologist.
That confirmed test, Mary?
Yeah.
Do we have a question in the back? The last thing, Tom Hayes, Little Two, was on a case for where the department asked for a specific test for heroin. And the question was, wouldn't it show for opiates? And apparently, he talked to Pacific Toxicology, and it doesn't break down whether it's heroin or whether it's any other type of opiate. So if a client is, we were wondering whether we were going to challenge the request for the test. If there's an accusation of heroin use, a regular test will not show heroin specifically because the department doesn't pay for that test. That they would have to have special funding to pay specifically for a heroin test. So if you have a client that is being accused of use of heroin and the department wants to do a special test, it's because the regular opiate test won't show.
Well, I heard Tom when he was talking, and he said that apparently it's different people. So some people metabolize it differently, so it's not uniform. So some people can show up even in the basic test the department does, and then for other people it doesn't, which was interesting.
Hire an expert.
Hire an expert. And also, and I'm sure everyone already knows this, but I was just thinking, I had another case today that I'm all riled up about. I'll tell you about it later. But the woman is she's very large. And so we've learned from these toxicologists that people who have higher fat content metabolize marijuana differently. So she had reported that she had stopped using marijuana about 2 months ago, and they say in the report, well, she should be testing negative now. And that's not the case. So if that becomes the problem at the jurisdictional hearing, hire the expert to talk about how different people metabolize marijuana differently.
And they can go up and down. So the people that say, oh, the levels shot back up, if they're not going up really significantly, that's not abnormal necessarily. So
Exactly.
be mindful of that. It's not necessarily indicative that they went out and used the night before.
Right, right. And these tests, I think, have gotten more important because of Alexander C. and these other cases. Previously, I was not as worried about them. I sort of was like, it doesn't matter if they're testing positive, there's still no nexus. Well, now we have to deal with them. So I do urge you to talk to your supervisors and your firm directors and think about hiring experts. Thank you guys so much for coming. Oh, thank you.